Not okay. You think anything about this is okay right now?
Body cam footage submitted by Janet of Union County, Illinois shows her son, suffering from meth-induced mental illness, being tased by police officers. Imagine parents calling 911 for an ambulance, and instead police officers, aware that they have a warrant for the son, arrive instead of an ambulance. And they don't bring an ambulance. And instead of medical treatment, they use force. This offers a good example of what I would classify as a controversial use of a taser against someone who poses no threat to the officers or anyone else, but is merely starting to run away, and doing so immediately without explanation or warning. Let's take a look at the footage, and then we'll go into the law on tasering unarmed suspects in Union County, Illinois, which is in the 7th Circuit. First, let's play the initial 911 call. Jacob Anderson's father called 911 seeking an ambulance for his son, who was suffering from a mental illness emergency due to his unfortunate meth addiction.
911, what's the address of your emergency?
I'm trying to call an ambulance. Do I have to call the hospital?
No, sir. We dispatch an ambulance. What do you got?
It's my son. He's psychotic right now. He's in a psychotic state.
Okay.
He had a relapse about a couple weeks ago, and he's going nuts.
An ambulance never arrived, however, but several police officers did arrive, including Deputy Schaldknecht. I don't know if I got that right, who turned on his body cam after arriving at the Anderson home. According to his report, he noted that he received a report that Jacob was having a mental health crisis, described as psychotic, and that an ambulance was needed. He then wrote, "I also knew that Jacob had a felony warrant, as well as a history of running away naked from help when we arrived." Upon arriving, the deputy made contact with Jacob's parents, who indicated that Jacob was inside the residence and appeared to have let them in.
It's this one, right? Right here? Shut up, Todd. That one?
I don't know. Oh.
Hello.
Is this the one different from this one?
Yeah.
Sheriff's office! Yep.
Oh, hey, hey! Please stop.
Deputy Schaldknecht wrote in his report, "As I approached the door, I could hear a male yelling. I then withdrew my taser and knocked on the door. I then heard the male yell, 'Come on through, I'm going to the side door.' As I walked through the residence and came to the side door, Jacob saw me, turned and began to run away from me. At this point, I raised and fired my taser at him as he ran away. I was unable to issue a warning to him because the situation evolved so quickly." He wrote that he allowed the taser to run for a 5-second cycle until Sheriff Harville and Chief Wilkins could get there to assist. He also mentioned in his report that after the arrest of Jacob, I realized he broke my Oakley mercenary sunglasses he had been wearing. He attached a photo of them to the report, noting that he had paid approximately $140, well, the government taxpayers did, 2 years ago.
Oh, that's not
Here.
my
We'll take it. No, if it's Jacob's, it's going into evidence. Did you grab that taser, Scott?
I didn't get it. I'll go get it.
Yeah, it's a taser. We're grabbing it. It's not okay. You think anything about this is okay right now? All right. All right.
Are we going to sheriff's office?
We can't.
Because they're going to have to.
I know. Let's get the ambulance service up to the office.
We ought to just take him to the hospital, Scott. We don't want to fight him in the back of an ambulance.
Yeah.
That's true. Let's take him.
I'm trying to be a dick, but
I know.
I say we just.
I agree. But we're going to have to get some more minutes out there because he's on the line.
County K-9-1.
The International Association of Chiefs of Police puts out a model taser policy, which provides guidance to law enforcement agencies around the country about taser usage, when it should be used and when it should not be used. This is not law, this is their policy. This is what they provide. It should be used to protect the officer or others from reasonably perceived immediate threat of physical harm from the person to be exposed to the taser, or to restrain or subdue an individual who is actively resisting or evading arrest, or to bring an unlawful situation safely and effectively under control. It should not be used, according to this model policy, on individuals who passively resist and are not reasonably perceived as an immediate threat or flight risk, or individuals in restraints except as objectively reasonable to prevent their escape or prevent imminent bodily injury to the individual, the officer, or another person. Or when the officer has a reasonable belief that deployment may cause serious injury or death from situational hazards, including falling, like down a hill and hitting your head on a utility box, like the Atlanta case we talked about, or drowning or igniting a potentially explosive, flammable material or substance, such as the case where the guy doused himself with gasoline, they tased him, and he blew up and died. Except when deadly force would be justified, or when the suspect's movement or body positioning prevents the officer from aiming or maintaining appropriate body part targeting, really presumably based on generalized excessive force case law from the federal circuits around the country. And taser law can vary some by federal circuit. So Union County, Illinois is in the 7th Circuit, and there are quite a few published cases in the 7th Circuit about when taser usage is considered excessive. There was a 2009 case called Lewis versus Downey, which held that the tasing of a jail inmate with no warning who wasn't threatening the officer would be excessive. And it ultimately discusses tasers and categorizes them as basically an intermediate level of force that's designed not necessarily to cause injury, but severe pain. And the courts noted that generally the holdings out there find that the use of a taser against an actively resisting suspect, whatever that is, does not violate clearly established law or is constitutionally reasonable. Thus, actively resisting may or may not be sufficient justification for police to use a taser on a suspect. So what about active resistance from someone who's known to be mentally ill, or who is not actively threatening anyone, but merely trying to run away? Somebody who's mentally ill. So there's a 9th Circuit opinion called Bryan versus McPherson, where a court warns situations where a suspect is known to be mentally ill, emotionally distraught, is different than where somebody who is an armed and dangerous criminal and has recently committed a serious offense. The use of force that may be justified by the government's interest in seizing a mentally ill person differs both in degree and in kind from use of force justified against a person who has committed a crime or who poses a threat to the community. Now, the 7th Circuit has cited the 4th Circuit published opinion in Estate versus Armstrong versus Pineville, which held that where during the course of seizing an outnumbered mentally ill individual who is a danger only to himself, police officers choose to deploy a taser in the face of stationary and nonviolent resistance to being handcuffed, those officers use unreasonably excessive force. Utilizing the Graham factors in this case, we can skip to the most important of the Graham factors: whether the suspect poses an immediate threat to the safety of the officers or anyone else at the scene. The video in this case proves conclusively that there was no safety threat posed to any individual by Jacob. He was running away, he clearly wasn't holding a weapon, nor was he threatening anyone. Reviewing the deputy's report, he admits that he tased Jacob in the back as Jacob turned away to run. He mentions no immediate safety threat as the basis for his use of force. Now, the second Graham factor is met to some extent for the officers. He was actively evading them. However, they had not announced their presence, nor the reason for their presence. They had not identified themselves. They had mentioned that they had a warrant. They pretty much instantaneously encountered him and then tased him. Was merely running away from the sight of law enforcement sufficient to constitute active resistance, whatever that is? Now, was that sufficient for a 5-second shock from the deputy's taser? Let's look at the first and final Graham factor that we haven't discussed, the severity of the crime involved. There's no allegation that Jacob had committed any crime on this occasion. This was a mental health emergency his parents called 911 requesting an ambulance. But he apparently did have an outstanding, unnamed felony warrant. The officer's report doesn't mention any serious crime that Jacob was alleged to have committed so as to necessitate having to immediately tase him. Moreover, the reports also indicate that the officer was well aware of the fact that Jacob was suffering from a mental illness episode. Thus, the courts expect the officer to take that knowledge into account when deciding whether or not to tase Jacob, as opposed to just tasing him first and asking questions later. As always, thanks for watching. You'll find more information at the blog at the link below, thecivilrightslawyer.com. If you want to learn more about these cases and your constitutional rights, please subscribe. Hit the bell notification so you don't miss future updates, future videos. Please also comment. I want to hear your thoughts about this case. Do you think it was reasonable to tase Jacob here, basically at first contact? If you want to support the channel, please consider clicking the join button on YouTube and becoming a channel member or sponsor. Remember, freedom is scary. Deal with it. I'll see you next time.